Donald Trump has threatened to sue Trevor Noah, not over an investigative report or a factual news claim, but over a joke. A 30-second line delivered on the Grammy Awards stage referencing Jeffrey Epstein's island. At first glance, this might appear to be just another Trump outrage cycle. It is not. This moment matters because it reflects a broader and increasingly dangerous strategy, the weaponization of defamation law to suppress speech. From a prosecutor's perspective, Trump's response does not signal legal strength. It signals risk that could expose far more than he appears to have considered. On Sunday night, February 1st, 2026, Trevor Noah hosted the Grammy Awards for the fifth and final time. During the broadcast, Billie Eilish won Song of the Year for Wildflower. While transitioning between segments, Noah made a joke. Referring to Trump's repeated interest in acquiring Greenland, Noah quipped that it made sense because Epstein's island is gone, adding that Trump needs a new one to hang out with Bill Clinton. The audience laughed. Noah then followed with a pointed aside. "I told you it's my last year. What are you going to do about it?" By 10:01 the next morning, Trump responded on Truth Social with a lengthy, approximately 300-word post. This was not a casual dismissal. It was a direct legal threat. Trump claimed that Noah had falsely stated he spent time on Epstein's island, denied ever having been there, and asserted that no media outlet had ever accused him of such conduct. He then warned Noah to get his facts straight and get them straight fast, announced his intention to send lawyers, and referenced prior defamation settlements involving ABC News and CBS as proof that litigation against critics works. Trump's confidence is understandable in context. ABC News paid $15 million after George Stephanopoulos inaccurately stated that Trump had been found liable for rape when the legal finding was sexual abuse. CBS paid $16 million over an edited 60 Minutes interview. These settlements reinforce Trump's belief that defamation threats can be used to extract money and compliance, even when First Amendment defenses are strong. But this case is different in ways that matter legally, strategically, and politically. What Noah said was not a factual assertion. It was satire delivered by a comedian hosting an entertainment awards show. Under U.S. law, satire involving public figures receives the highest level of constitutional protection. That distinction alone makes Trump's threat legally fragile. But there is a deeper problem, one Trump's legal team should have recognized immediately. 3 days before the Grammys, on January 30th, 2026, Trump's own Department of Justice released over 3 million pages of files related to Jeffrey Epstein. Standing at the podium, the Deputy Attorney General declared that the release constituted full compliance with the Epstein Files Transparency Act. Those files include Trump's name more than 3,000 times. They contain emails in which Epstein and his associates shared news articles about Trump. They include photographs of Trump at Epstein-owned properties. They reference flight records suggesting Trump traveled on Epstein's private jet more frequently than previously reported. They contain testimony from an Epstein victim stating that Ghislaine Maxwell suggested she was available for Trump and his associates, while also noting no encounter ultimately occurred. They include statements from Trump's own Mar-a-Lago staff indicating that Trump and Epstein socialized regularly. Trump has consistently denied any criminal wrongdoing. He has never been charged in connection with Epstein. Neither has Bill Clinton. Both men deny knowledge of Epstein's crimes. Those facts matter, and they should be stated clearly. But from a legal perspective, another question matters even more. If you are about to sue someone for defamation over a joke linking you to Epstein, do you really want to open discovery on your relationship with Jeffrey Epstein? Because that is precisely what a lawsuit would do. Discovery is the most powerful tool in civil litigation. It allows both sides to compel documents, demand testimony under oath, and examine evidence that would never be released voluntarily. If Trump were to sue Noah, Noah's attorneys could subpoena every communication between Trump and Epstein, every flight log, every photograph, every witness statement, and every document released by the DOJ. They could depose Trump personally, under oath, for hours or days. They could question him about every entry in the Epstein files bearing his name. They could subpoena Mar-a-Lago employees and associates. No prosecutor would willingly invite that level of scrutiny unless victory was essential and certain. This lawsuit would be neither, which brings us to Trump's real objective. Trump does not file defamation lawsuits to win trials. He files them to create a chilling effect. The pattern is consistent. He sues. The case drags on. Defendants face years of legal fees, uncertainty, and reputational risk. Many choose to settle, not because they are wrong, but because litigation is expensive and exhausting. ABC and CBS did not settle because the First Amendment failed them. They settled because even strong constitutional defenses cost millions to litigate. Those settlements sent a message. Criticizing Trump carries financial risk. Now Trump is attempting to apply the same pressure to a comedian. But the legal terrain here is fundamentally different. To win a defamation case, Trump would have to prove that Noah made a false statement of fact, that it referred to Trump, that it was published, that it caused reputational harm, and, because Trump is a public official, that it was made with actual malice. Actual malice requires proof that the speaker knew the statement was false or acted with reckless disregard for the truth. You cannot prove actual malice for a joke that no reasonable person would interpret as a factual claim. This principle was settled decades ago in Hustler magazine versus Falwell. In that case, the Supreme Court unanimously ruled that outrageous parody about a public figure, even deeply offensive parody, is protected speech so long as it cannot reasonably be understood as stating actual facts. The court explicitly warned that allowing lawsuits over satire would destroy political cartooning, comedy, and dissent. Apply that standard here. No reasonable viewer believed Trevor Noah was reporting verified facts during the Grammys. The laughter of the audience itself is evidence that the remark was understood as humor. There is another fatal flaw in Trump's threat. He mischaracterized the joke. Noah did not say Trump visited Epstein's island. He made a satirical comparison linking Trump's interest in acquiring Greenland to Epstein's island. An abstract, layered joke relying on public knowledge of Trump's documented association with Epstein. Trump's response attacks a statement that was never actually made. That mischaracterization would be devastating in court. And then there is timing. Trump's administration is under political pressure over the Epstein file release. Lawmakers are questioning why millions of pages remain undisclosed despite claims of full compliance. Allegations of selective transparency and potential cover-up are growing. Then, just days later, a high-profile joke revives public attention to Trump's Epstein connections, and Trump responds not with denial, but with a legal threat. From a prosecutorial lens, this looks like narrative control. Instead of answering questions about the files, Trump shifts the conversation. He casts himself as a victim of defamatory attacks. He reframes scrutiny as persecution, but legal threats often backfire. Every time Trump threatens or files a defamation suit, attention shifts to the underlying facts. The ABC settlement revived public focus on the E. Jean Carroll verdict. The CBS settlement reignited debates about media editing practices. This threat has already prompted millions of people to search for the Epstein files and read what they contain. And unlike news organizations, Trevor Noah has little incentive to back down. He is not preserving access to sources. He is not protecting advertisers. He openly stated it was his final year hosting. He has nothing to lose, and the strongest First Amendment defenses available. If Trump files this lawsuit, he would be choosing the worst possible defendant and the worst possible forum to test his intimidation strategy. He would expose himself to discovery, judicial scrutiny, and renewed public examination of his relationship with Epstein. That is not strategy. It is hubris. This moment is bigger than Trump or Trevor Noah. It is about whether powerful figures can use the cost and complexity of litigation to silence criticism. The Supreme Court recognized this danger in New York Times v. Sullivan, warning that democracy requires breathing space for criticism, even sharp, uncomfortable criticism, of public officials. When legal threats become tools of intimidation rather than justice, speech suffers. Journalists self-censor, comedians pull punches, citizens hesitate to speak. The law remains technically intact, but its protective function erodes in practice. Whether or not Trump ultimately files this lawsuit, the threat alone has already had an effect. But it may also produce consequences he did not anticipate. Courts are not social media platforms. Satire is not defamation. And discovery cuts both ways. What happens next matters, not just for Trevor Noah, but for the future of free expression, accountability, and the First Amendment itself.